So sometimes there is confusion about the percentage of a deceased worker's benefit amount that a surviving dependent family member usually would become eligible for as a dependent benefit if they are otherwise eligible. So let's just go through it. I know some people think it's 100% of the deceased worker's benefit. End of story. That's not really true. That's under a very specific circumstance. So we will go through that. I will post a button at the end for the link for the page that you're going to find all this under, in case it helps you to better, retain it or go through it again after we're done. Okay, so when does the 100% occur? That occurs if you're a surviving spouse and you do not collect at any time before you yourself are of full retirement age. Okay, meaning you do not collect the survivor benefit off of the deceased spouse's work record. So if you are 63 and you lose your spouse and you decide to collect at that moment, it is going to be something less than 100%. 100% will only apply if you wait until your own full retirement age. There is no benefit to waiting after your full retirement age. You're not going to gain any delayed earnings credits that way. But I will slip it in here that if the deceased spouse didn't collect a retirement benefit, let's say the spouse dies in the late 60s, early 70s, or beyond, and that worker did not file for retirement until he was 70 because he wanted to gain those delayed earnings credits, which can increase the lifetime monthly benefits by, I want to say like 30% over if he took it, say 67. It might be something less or more, but something in that range. It's pretty big. If he waited until at least 70, he's going to get the full maximum extra to his benefit. And the beauty of that is that extra from that delay will transfer to a surviving spouse. So again, if that surviving spouse waits until full retirement age to collect, she's going to get that full amount that he was getting. If he or she, the surviving spouse, feels compelled to take it earlier, cannot wait till 67 to collect, then it will be something less than 100%. Now, as a surviving spouse, you do not have to wait till you're 62 like a living spouse would to collect a spousal benefit. A surviving spouse can collect at age 60 instead of 62. I believe that would be a recognition of the fact that now they're hopped down to one income or no income if it was previously just the worker's income. So at age 60, however, you, like any other early retirement taking for the most part, it's going to be discounted. It'll be 71.5% of the deceased worker spouse's benefit rate. And that does not change. That doesn't change just because, 7 years later, you turn full retirement age. It will forever be that amount. So there is incentive, not conclusive, but incentive to delay until you're a full retirement age. If you are slightly below, it will go up to 99% if you are below retirement age, but very close. And then once you're full retirement age, it will become 100%. There is another provision for a surviving spouse who is under 60, but disabled. If you're under 60, if you're between the ages of 50 and 59, and you're disabled, and provably so, if you haven't already proven it before in front of the SSA, you would have to do so now and file for this. You can get 71.5% of your deceased spouse's benefit, even though you're not yet 60, 50 through 59. And I believe, although it's not on this page, that you have to have become disabled within 7 years of the passing of your spouse. So if you're already disabled before he passed, and you might not have been able to collect a benefit because maybe you didn't have a work record and you weren't poor enough via his income to ever get SSI, you might not have had a benefit, but if you can prove now that you were disabled, either before or within 7 years after he dies, you can be eligible for this age 50 through 59 surviving disabled spouse benefit. Okay. The other spouse that can collect is one who is caring for the child who's under 16. So, and that's a 75% rate. So once that child, though, ages out, then the surviving spouse, which is like a caretaker surviving spouse, can't collect that anymore. So it does take planning. I know of someone who had survivor benefits due to the loss of a spouse, multiple children, and didn't really prepare for when those children would be aging out and she wouldn't be getting that benefit anymore. She was not disabled, but she had opted to not work even when they were in school and of school age. So she really had very little to fall back on. When that did happen, she was forced to go out and get a job, a rather menial job because she hadn't worked on her skills of this whole time. So she wasn't schooling while her kids were in school. And she wasn't actually babysitting them when they were in school, but she didn't use that time to prepare for when that benefit would cease when the kids aged out. A different beneficiary who's not a surviving spouse would be a child, of course, who's under 18, right? Those are the dependents, or under age 19 if still in elementary or secondary school, or a child who has a disability, and that amount is 75% for those children. Remember that there is the DAC benefit, disabled adult child benefit. So if the child is over 22 but can prove that he was disabled under SSA standards before the age of 22, he or she too can get that 75%. And I'm going to go just make a little comment at the end about when we say can get up to 75% or up to 71.5% or up to some percentage. So hopefully I'll remember to speak to that because it's really important. The last major area would be, and we don't see it a lot, but dependent parents of the deceased worker. If they are at least 62 and they receive, let's say there's 2 surviving parents and they receive, they were dependent on the deceased worker as defined by the SSA. So the deceased worker was financially supporting them. They can each get 75%, up to 75%. If there's only one surviving parent, it goes up a little bit to 82.5%. They do add that surviving divorce spouses are also able to collect here. So it's all the same as a surviving existing spouse. The divorced spouse can also collect. Okay, my comment about the percentages. Yes, you can get up to 71.5%. Yes, you can get 75%, but those are all subject to that family maximum. I believe we've talked about this elsewhere. So if there's 10 children surviving, they're not going to each get 75% of, say, dad passes away, dad's benefit, because there is a family max. The family max is going to be generally between 150% and 180% of dad's benefit amount, or mom, whoever's the deceased worker parent. So as you can tell, if it was 150%, which is, it's a lower amount for lower income workers, it gets higher as our income was higher during our working years. At 75% maximum per child, 2 children are going to eat up the full 150%. Remember, it's 150% because dad's 100% is no longer being taken by dad, so that's available. So at 150%, 2 kids can collect the full amount and nobody else. Now, of course, if there is more, they're not going to say you 2 get it and nobody else gets it. It's going to be prorated. So everyone's going to be paying off the top. Maybe they're each going to get 20%. Maybe they're each going to get 7% if there's a ton of them in there. And the surviving spouse would be part and parcel with that. That would be a piece of the pie. I believe the only thing that isn't a piece of the pie is the surviving divorced spouse. I don't think that cuts into the existing spouse and children's benefit. Haven't really delved into what if that surviving divorced spouse has 7 kids. But I do, so those probably would be affected, but I think the divorced surviving spouse herself does not cut into it. I suppose if that's so, it is probably because, can you imagine the acrimony between existing spouses? I mean, there's acrimony a lot of the time anyway. Can you imagine if now you thought that your income to your family was being curbed because of him or her? Ooh, that would be pretty crazy. Anyway, so just wanted to let that be known, and never forget about the family max, because you will be overestimating your collection of benefits from various people in your household. If you don't recognize it, it's going to be nipped in the butt at the family max. Okay. And you could probably call the SSA field office to find out what your family max is if you find that you're involved in a situation like this. All right. Have a great one, guys. Bye.